So this is what we call the litigation roadmap. Keep in mind that 98% of our cases settle, but the litigation roadmap is just to give you an understanding of what typically happens in most cases. In most cases, or 98%, they settle, but many of them go through these same processes before you get to trial, without going to trial, and these steps are very important. These steps are what I call the pinch points on insurance companies. So, what are these steps? The first step is the filing of the lawsuit. This is important because it brings the parties to the table and makes everybody subject to the same rules. They have to answer discovery, you have to answer discovery. They have to give a deposition, you have to give a deposition. And we prepare you for all of that. So the first step is filing the lawsuit. It brings everybody to the table and requires a certain thing. The second step is the discovery, which includes interrogatories or written questions under oath. And these are just things that they have to answer as well as you. They're easy. You and I review these together. You don't have to worry about putting the wrong thing down or saying the wrong thing. All we want you to do is tell us the truth and give us the data that's required to answer these. The third thing are depositions of the parties primarily, where you will be involved. And that is just simply where you'll sit at a table like this. It'll be me, you, or our attorney and you, a court reporter, perhaps a videographer, maybe, maybe not, and the other attorney and the other party is sometimes present in the room. So these are just statements under oath. We spend a lot of time preparing you for that. All of my clients always tell me, John, thank you for preparing me for that. I knew everything that was coming my way. I saw it before it came out of their mouth. I'm like, very good. I love hearing that. The next step usually is mediation, and this is a free day for you. You don't have a lot of pressure. It's a day where everybody takes some time off to do nothing but focus on you and your case. No other cases, no other phone calls, no other conference calls, no other meetings with court. It's just a time set aside with the other attorney, their insurance representative usually, and a mediator. A mediator is a neutral party that's designed to bring both sides to the table and try to have the parties reach an agreement. We don't have to settle at mediation. It's great if we do. We settle about 60 or 70% of our cases at mediation, but just because you don't settle at mediation doesn't mean your case still won't settle. Most of my cases, even the ones that fail at mediation, which is about 30 or 40%, still about 98% of those settle before trial. So it's just the next step to push the case forward. So I hope this gives you a little bit of clarity. After mediation, and the mediation can occur at any time. It doesn't have to occur after depositions. It can occur before you even file suit sometimes. There's no specific parameters on that. But usually after party depositions, the insurance companies want to mediate the case. So I hope this helps. Click on the link below for more in-depth for each of these processes that we've discussed. And I hope this gives you insight into better understanding your case. Thank you very much.